So just perhaps to set the scene a little bit before we deep dive into the foundation as an estate planning vehicle. Obviously, we are talking about the foundation as a vehicle for estate planning. So it's important for us perhaps to start with estate planning and understand what it means and what is it that estate planning aims to achieve. Now, when we are talking about high net worth individuals or ultra high net worth individuals, obviously, one of their major goals would be to preserve the wealth that has been created by them so that they are able to safeguard the lifestyles of generation to come. It's obviously hard enough to acquire wealth, but protecting it, preserving it, and passing it over to successive generations can be an even greater challenge. Which reminds me of that Chinese proverb, and please excuse me because I will actually provide you with a translated version because I don't speak Chinese. And that proverb basically says that the wealth of a family never lasts for more than 3 generations. What does that mean in practice? It actually means that generally the first generation will work very hard, right, to build the family fortune. The second generation will reap the benefits. And then the third generation will squander the wealth. Because whilst the second generation may see the value of hard work, the third generation, which is sort of so detached to the first generation, often forgets about it. And there are a number of reasons why wealth that has been created in the third generation doesn't make it to the third or the fourth generation. And there could be many causes, you know, young family members who are probably not prepared or not willing to shoulder the responsibility of wealth stewardship. You know, they have grown up with plenty of money and are really a step or two removed from the work ethic and drive of the people who made it for them. But there are also other reasons, you know, taxes, inflation, bad investment decisions, and also the natural dilution of assets as they are shared among generation of heirs. And that's where estate planning becomes very important, because estate planning is the process of anticipating and arranging during your lifetime for how your estate is going to be disposed after you've passed. And the purposes are multifold. It aims to eliminate uncertainties over the administration of a probate. It aims to maximize value of the estate. It aims to ensure that the wealth is adequately preserved, is adequately protected, but most importantly, is adequately passed over to successive generations. So that's what estate planning is all about. How do you create a proper estate plan? Well, you need to use certain tools in order for you to achieve these objectives that I referred to earlier on. And there are a number of tools that can be used to create an estate plan. And the most known of the tools would be the trust. The trust has been one of the most important estate planning tools that have been used by high net worth individuals for centuries. As you may know, the trust concept is a very old concept. It finds its origin in the Crusades in England, and they have a long history. And the reason why trusts are popular is because they allow for the management and enjoyment functions of ownership to be split between different functions. Let me explain what I mean. Generally, if you are an owner of something, of an asset, it could be, you know, money, it could be a building, it could be cash, it could be jewelry, then you have both the power to deal with the asset, and you also have the ability to enjoy the asset. An owner has both You know, power to deal, i.e., you could sell it, you could pledge it, you could gift it. But you can also enjoy it if you've got a car, you've got a nice car, you can drive it. If you have a piece of jewelry, you can wear it. If you have a house, you can live in it. So an owner normally has the power to enjoy both the have the enjoyment of the property and also to deal with the property. But where an asset is held in a trust, the role of management is vested into a trustee, who is the legal owner of the asset, whilst the enjoyment of the thing which is subject to the trust is vested in the beneficiaries, who have an equitable interest in the assets. As legal owners, trustees are capable of dealing with a property in the same way as an absolute owner would, but because they cannot benefit from the property, but they're holding it for the benefit of beneficiaries, they need to have regards to the rights and the interests of the beneficiaries in the exercise of their powers. Additionally, a trust can be set up as a discretionary trust so that the interests of the members of the beneficial class don't have an immediate vested interest in the trust assets. And such type of trusts, as some of you would know, offer a number of advantages, including flexibility, asset protection through ring fencing, and tax planning, amongst others. So the trust certainly is a product that is very well suited to estate planning. However, foundations are a newcomer, but are being increasingly considered by practitioners in the context of private wealth management and or charitable giving. And we'll see why in the next few slides. It is quite a new product. It's around a century old. It finds its origin in 1926 when Liechtenstein created the Family Foundation by the law of person and companies. But today there are a number of jurisdictions which have a law on private foundations, including Mauritius. There are not many, there are probably about 10, and Mauritius being one of them. What is a foundation? And here we'll focus mostly on the Mauritian foundation. Foundations were introduced in our legal system in 2012. I was personally very involved in the introduction of the Foundations Act of 2012. It was a long-awaited piece of legislation which further broadened the product offering of the jurisdiction, especially in the context of private wealth management. Now, why are foundations gathering popularity? They are gathering popularity because the nature of the foundation, as we will see later on, makes it quite appealing to four main categories of situations. There probably are more, but these four categories of situations are well suited for foundations. First of all, clients from civil law jurisdictions who are less familiar and less at ease with the common law trust concept. And very often when I talk to clients from civil law jurisdiction, they find it very difficult to come to terms with that split in ownership, which is quite alien to civil law. They are also quite wary of transferring their hard-earned assets to a third-party trustee who becomes the legal owner of these assets. So these types of clients find the foundation to be more appealing than the trust. Secondly, clients who want to have a continued involvement in the management of their assets, which is normally not possible with a trust, or very difficult to achieve with a trust, because you have to look at reserve powers, which are dangerous, or you have to use protectors, advisors, sometimes private trust companies, which makes it become very complex and costly at the same time. And whatever you do in a trust, you'll never be able to give a client control over the assets without jeopardizing the trust. So there is a limit to what you can do, but as we will see later on, foundations lend themselves much more to the client keeping control and keeping influence in the management of the assets of the foundation. Third, those who are wary about sham arguments, which is very common in the case of trusts. Those of you who have worked with trust would have come across a lot of case law on the sham argument, where the court basically holds that although a trust has been set up to hold assets, circumstances around either the setting up of the trust or the management of the trust mean that the trust is actually a sham. So the court takes the view that there has been no trust at the outset. And therefore, this poses a lot of problem, because obviously, if you thought there was a trust and then it turns out that there was no trust, then there's a lot of trouble, believe me. For example, if you are a professional trustee and you've charged fees, you'll have to refund all the fees that you've charged, because you couldn't have charged fees as a trustee if there was no trust. And fourth, where the assets of the client are exotic or volatile in nature, you will see later on why a foundation is also more beneficial or more acceptable when you have assets that are exotic or volatile, and you know, especially today where you have things like bitcoins, you might find that typical trustees are not very keen on being a trustee of a trust that holds exotic or assets that are volatile in nature. And for these reasons, it's not surprising that foundations are expanding in popularity across the globe. You know, even in Mauritius, ever since the law was enacted, we've seen a lot of foundations being created as opposed to trusts. So let's move on now to look a little bit more about a little bit more on the specificities of the Mauritian Foundation and see how, for what purposes can they be set up, how are they set up, how are they governed, issues such as confidentiality and taxation, before we finish with a comparison between the trust and the foundation, and perhaps try and see which one is better and in which circumstances would one be preferable over the other. So in terms of purposes and objects, it has to be said that the foundation is very similar to the trust, and therefore a lot of the facets of the foundation of the trust, okay, would also be similar when it comes to foundations. So for example, when you look at the purposes and objects of a foundation, is very similar to those of a trust. So you can set up a foundation for any purposes as may be provided in the charter. So the charter is the constitutional document of the foundation. So for a trust, you have a trust deed. A company has a memorandum and articles of association in certain countries. In Mauritius, it's called the constitution. And for a foundation, it's called a charter, right? Now, so a foundation can be set up for any purposes as may be provided in the charter. These purposes can even include the carrying out of objects specified in the charter. And obviously these objects or purposes must be valid and enforceable, must not be contrary to the laws of Mauritius. So long as they are not contrary to the laws of Mauritius, they would therefore be valid and enforceable. So now the objects can be charitable, non-charitable, or both. And they can be for the benefit of a person, a class of persons, to carrying out a specified purpose or both. So it's quite flexible. You can have hybrid foundations, which could be for a mixture of charitable and non-charitable purposes, i.e. you could have a foundation that is both for the benefit of beneficiaries and also for charitable purposes and non-charitable purposes as well, right? And charitable purposes are defined as advancement of education, relief of poverty, advancement of religion, protection of environment, advancement of human rights and fundamental freedoms, or any other purpose beneficial to the public in general. So you have the same charitable purposes for foundations as you have in the Trust Act. But interestingly, if you are setting up a foundation for charitable purposes, it's interesting to note that the Foundations Act does not require to demonstrate public benefit. In the case of a charitable trust, you have to demonstrate public benefit, but there is no public benefit requirement for charitable foundations under the Act, right? So could be preferable if you are setting up a charitable venture to structure it as a charitable foundation instead of a charitable trust, okay? And if you are setting up a charitable foundation, it's also good to know that the charitable objects do not need to be pursued in Mauritius or need to be beneficial to the community in Mauritius, okay? Because obviously Mauritius being an international financial center, a lot of clients would use Mauritius as a base to set up the foundation, but to further purposes or objects that are outside of Mauritius. So let's now look at the founder and the endowment. So as I said before, a foundation is basically a structure that is created by someone who would endow property to it so that this property can be held and managed for certain purposes or for the benefit of people. So a foundation will be created by a founder who can also be a beneficiary of the foundation. And again, interestingly, presumably, the founder may even be the sole beneficiary because the Act does not say otherwise. Those of you, again, who know how trusts, Mauritian trusts operate, would recall that the Mauritian Trust Act prevents a trust to be set up by a settlor where he is the sole beneficiary. So there's a difference, again, between the foundation and the trust, because a foundation could presumably be set up with only one beneficiary, who is the founder. In respect of a founder who is a non-citizen, so that will apply to all of you on this call who are not from Mauritius, who are non-Mauritian citizens, there will be a presumption that the founder has the capacity to endow the property to the foundation, so long as he's of full age and of sound mind, either under the laws of Mauritius or that of his domicile or nationality, or the proper law of the transfer. And the reason why we included that section in the Act is very simple. It's because we didn't want anyone to come and challenge the foundation on the basis of lack of capacity of the founder, right? Because obviously, if you were able to show that the founder did not have capacity to endow assets to the foundation, then you could basically say that the endowment, therefore, is null and void. You should return that to the founder. But we've provided that where the founder is a non-citizen, there's a presumption that there's capacity, right? So we presume that the person has capacity and there is no need to scrutinize whether he actually has the capacity or not, provided that he's of full age and of sound mind. We also included firewall provisions in the Foundations Act, which is similar to the firewall provisions we have in the Trust Act. And that's essentially aimed to prevent an endowment from a non-citizen to be set aside because of inheritance or succession rules in the founder's country of domicile, or because of issues in respect of marriage, So these are effectively firewall provisions to prevent the foundation being attacked, right, by maybe a disgruntled a spouse or a disgruntled heir, right? So we have firewall provisions to prevent that from happening. How do you set one up? If you wanted to set up a foundation, well, you can set up a foundation either inter vivos, which means during your lifetime, or by will, right? So you can set up. So if you want to set up a foundation by will, then you would provide for it in your will, and it's only when the will comes into effect that the foundation as well will come into effect, right? Or you could set up the foundation during your lifetime. And my advice is always, if you want to create a foundation for an estate plan, do it as quickly as possible, right? Don't wait too much. And certainly, I think, don't leave it to your will. Because the whole idea of setting up a trust or a foundation is to avoid using a will for estate planning, because of all the benefits that you get through a trust or a foundation and that you do not get through a will. Process is very simple. You start by reserving a name. So it's just like creating a company. You pick a name, you make a reservation of name to the registrar, and if the name is available, then you lodge an application for the establishment of the foundation. The application must include certain information: the name, the duration of the foundation, if it's a foundation of a limited duration, the purposes, the objects, the particulars of its registered office, the particulars of the secretary, the members of the council, the details of the beneficiary of a foundation, how they may be appointed and removed. These have to be submitted to the registrar. It's important to note that you do not need to submit the charter. The charter needs not be submitted. You simply need to submit certain information that you extract from the charter, right? Now, very often, if you are setting up a foundation as a discretionary foundation, we'll say a few words on that later on, then you would not even provide any details on the beneficiaries to the registrar when you're setting up the foundation. And very often what practitioners would do is the charter itself would not refer to the beneficiaries, but the charter will allow the council to nominate beneficiaries through regulations, right? We'll come to that a little bit later. But I think the reason I say this is because it's important to note that you are not disclosing all information to the registrar, but only very limited information to the registrar, because I know that a lot of clients could be concerned about confidentiality, and I just wanted to make that clear. There are also some other formal requirements for the application. You need to submit a list of names of the first officers. You need to have a legal certificate from a legal practitioner. You need a declaration as to the truthfulness and correctness of information, and obviously you need to pay the relevant fees. And then once you do that, if the registrar is satisfied that an application for the registration of the foundation complies with the law, then it will register the foundation in the register and issue a certificate of registration. So very similar to a company, which will normally be issued with a certificate of incorporation. A foundation is issued with a certificate of registration. And that's again one of the fundamental differences between the trust and the foundation. The foundation is a legal entity with separate personality. And the issuance of that registration certificate from the registrar will be conclusive evidence that the foundation has been registered on the date specified in the certificate of registration and shall have separate legal personality as from that date. And that's very important, and you'll see why in a moment. How is a foundation governed? Those of you who know trust will know that a trust is governed by trustees. A foundation is governed by a body which is very similar to a board of directors of a company. It's called the council. It will have members in it, right? And under Mauritian law, the council must have at least one member ordinarily resident in Mauritius. Although there is no requirement for that member to be licensed. And again, if we make a parallel with the Trust Act, you would probably know that every trust needs to have a licensed trustee in Mauritius. A foundation needs to have one member in Mauritius, but it doesn't need to be a licensed member, right? So it could be anyone. Could be anyone. This is a service that Axis provides, for example. If you are setting up a foundation in Mauritius and you need someone to act as a resident council member, this is something that we provide. We would step in, myself or my senior colleagues, as the member of council, ordinary resident in Mauritius. Council members are appointed in accordance with provisions of the Charter and of the Act. They have duties that are similar to that of company directors, not to trustees, right? So that's very important as well. Those of you who do a lot of trust would know that trustees, for example, are personally liable for breaches of trust. So council members are not generally personally liable, right? They are like directors. Okay, they have obviously certain duties. They have to ensure that they are conducting the affairs of a foundation in accordance with the charter and the articles. They need to supervise the management and conduct of the foundation. They need to act honestly, in good faith, with a view to promoting the best interests of the foundation. They need to exercise care, diligence, and skills that a reasonably prudent person would exercise in comparable circumstances. So all of that makes you, remember the duties of directors. It's very similar to the duties of directors. Interestingly, you can add to those in your charter. So if your client wants to have more duties imposed on the directors, you can add to those duties in your charter or in your articles, right? So the articles are the regulations. Some jurisdictions call them regulations, some call them articles. We call them articles, actually. I know I referred to regulations before, but the proper terminology is articles, okay? So you can provide for more duties, more powers in your charter or your articles. It's also possible for the client to provide a letter of wishes to council to guide them in the administration of foundation. So in that sense, again, similar to a trust. And again, a letter of wishes is non-binding. It's only a letter of wishes. The council might find it useful to have guidance in order for them to administer the foundation, but it's not binding. Founders can reserve rights to themselves if they want to, but most interestingly, they can also be a council member, right? In the case of trust, we don't like clients to be trustees because it can jeopardize the trust. It can make them resident in another country. It can make them shams. But a foundation is different because it's a legal entity, has separate personality. And therefore, for the client to be a council member would not necessarily give rise to a sham issue. Okay, we'll come to that a little bit later, but the client can be on council, and therefore by being on council can be involved in the way that the foundation is managed. He can influence, he can partake in decision-making process of the foundation, right? Now, if the founder is a resident of Mauritius, then there is nothing that prevents the founder from being the sole council member of the foundation, right? And presumably the sole beneficiary, okay? Although one has got not to also stretch it too much, right? So that a court of law that looks after it basically decides that, look, nothing has changed. You are still, effectively the owner of the asset because you're the founder, you're the council member, you are the sole beneficiary. So we must not stretch it too much as well. But there's nothing that prevents the founder from being a council member. And that's the point I wanted to make. And also, in trust, you can only have a maximum of 4 trustees. There is no limit as to the number of council members you can have on a foundation. What is the liability of council? Unlike trustees, council members are not generally personally liable for loss caused to the foundation unless they have been fraudulent or grossly negligent. Okay. Also, it's important to note that duties are imposed on council as a collective body and not on individual council members, right? Council can delegate its duties very much like trustees can delegate their duties. There's nothing in the Act which prohibits the liability of council to be excluded, but you cannot exclude liability arising from fraud, willful misconduct, or gross negligence, which is quite typical and understandable. Every foundation must have a secretary in Mauritius. That must be a licensee, by the way. So the secretary must be a licensee, such as Axis. The council member needs not, but the secretary must. And there are certain restrictions on who can be a secretary. Interesting also to note that the Act does not spell out the duties and powers of a secretary, and it is therefore assumed that the secretary will have the same type of duties or powers as that of a company secretary. Protectors are allowed. So this is borrowed from the trust legislation. As you know, trusts, there is the possibility of having a protector, and a protector is a person who is appointed to direct or to restrain the trustees in relation to the administration of the trust. And in the context of a foundation, a protector would be there to advise council or to consent to the exercise by council of any of their powers or discretions. Okay, they can be given additional powers. The law allows the charter to determine what shall be the powers and duties of a protector or committee of protectors. So it's very wide. So the client can decide the type and the extent of powers that he or she wants to give to the protector. The client may choose to give certain powers which he or she believes are already fundamental, such as the power to remove council members, to migrate the foundation elsewhere, or the client may just provide the protector with the power to have to consent to certain specified actions of the council, either conditionally or unconditionally. So it's quite flexible. The Act gives a lot of flexibility to the powers you can give to the protector. Every foundation needs to have a registered office in Mauritius to which communications and notices may be addressed and which shall constitute the address for service of legal proceedings. The registered office will normally be that of the secretary, i.e. if Axis is your secretary, then it is our registered office that will also be the registered office of the foundation. And like companies, you can change the registered office by a resolution of council and move it somewhere else in Mauritius. And also there is a need to have proper books of accounts, no audited financial statements, but book of accounts, and to keep those records in Mauritius at your registered office. One of the common questions that I get asked very often is about confidentiality. How confidential are foundations, right? Now, as I said earlier on, although foundations need to be formally registered, there is no requirement for the foundation charter to be registered, but simply for minimum information to be extracted from it. Information filed in respect of offshore foundations, i.e. a foundation which is founded by a non-resident of Mauritius and where the beneficiaries also are non-resident of Mauritius, are not available for public inspection. And there is confidentiality enshrined in the Act itself in Section 46, which provides for the instances where information can be provided, which, as you would see from the slides, or quite limitative. Obviously, I have to say that the above is subject to the requirements for information to be exchanged on the basis of bilateral or multilateral treaties. There is no absolute confidentiality anymore across the world, okay? Because there will always be either requirements for exchange of information under bilateral treaties like double taxation avoidance agreements, like tax information exchange agreements, or multilateral treaties, FATCA, and especially the CRS. So the absolute confidentiality does not exist anymore. And clients need to understand that and need to adapt to this new paradigm. How foundations are taxed? Well, foundations are taxed very much like trusts. Our income tax law makes a distinction between a resident foundation and a non-resident foundation. Put simply, a foundation will be non-resident when the founder is non-resident and all the beneficiaries appointed under the terms of the charter or the will are throughout an income year non-resident in Mauritius. So if a foundation qualifies for non-residency, it's exempt from taxation in Mauritius. It wouldn't pay any tax whatsoever. If a foundation is not a non-resident foundation, then it will de facto be a resident foundation. It will be taxable on its chargeable income at the rate of 15% per annum. As you know, Mauritius has a flat standard rate of tax, which is 15%. But the foundation can avail of one of two things. It can avail of the actual foreign tax credit system or the partial exemption system. In both cases, it will be where the foundation is receiving foreign source income. And because in most cases, because our clients would mostly be foreign clients and the foundation therefore would hold mostly foreign assets, in most cases, the income that would be derived by the foundation would be foreign source. And therefore, if it is foreign source, there are these two systems that could be availed of. What is the actual foreign tax credit? It's very simple. Under that system, any foreign tax that has foreign tax that has been applied to the foreign source income is allowed as a credit against the Mauritian tax payable. So let me take an easy example. A foundation, say, holds shares in a Kenyan company, right? The Kenyan company is itself subject to a corporate tax rate, say, of 15%. And then there's a dividend distribution tax of, say, 10% in Kenya before the dividend is paid. So when you look at the income that is coming from Kenya, the company is declaring dividends to the foundation, which is a shareholder. That income has been subject to 10% of withholding tax on dividends, right? Dividend distribution tax. It has also been subject to underlying tax of 15%. The corporate tax is under the underlying tax. Both of them are allowed as credit against the Mauritian tax payable. So in effect, the foundation would not pay tax in Mauritius because the 25% of tax that the income has been subjected to would be more than enough to wipe off completely the 15% chargeable tax rate in Mauritius. So by using the actual credit in such a situation, the foundation will end up not paying any tax. If the actual tax credit system cannot be used, either because, say, for example, the company in Kenya is a company that is subject to tax holiday, so it doesn't pay tax, right? Or there is no evidence to support the fact that the income has been subject to foreign tax, then you can use the partial exemption system. Under the partial exemption system, certain types of income, such as foreign source dividends and interest, will benefit from 80% tax exemption, subject to meeting certain substance requirements. Okay, so this means that in most cases, even a resident foundation will pay no more than 3% of income tax in Mauritius, because either it is able to wipe off the 15% completely through foreign tax, actual foreign tax credits, or it will use a partial exemption and will get 80% of tax exemption, which would bring its effective tax rate to 3%. So therefore, non-resident foundations, 0%, resident foundation, generally between 0 to 3. There might be certain exceptions where it will pay full-blown 15%. For example, a resident foundation of Mauritius, which is receiving Mauritius source income, which is not exempt income, will have to pay 15%, right? But otherwise, it's between 0 to 3. So to finish up, I thought I'd just conclude by looking at foundations versus trusts and just see which one is preferable, right? Is there one which is preferable? I think that foundations have most of the attraction for trusts and therefore can be used for all the purposes that trusts are used for. The benefit of a foundation is that it's an independent legal person, whereas a trust is only a relationship. The benefit of the legal personality, it leads to a number of advantages. Number one, assets can be held directly by a foundation, unlike a trust where the assets are held by the trustee on trust, right? This can pose problems in the context of a trust, because if there is a need to change trustee, you would have to transfer the assets. And therefore, there could be certain tax or registration duty issues if you are transferring assets from one trustee to the other. Number two, the fact that you have legal personality means that the foundation is holding the assets directly. As I said before, trustees are not really happy to hold assets that are wasting or volatile, because trustees have a duty to diversify, they have a duty to act prudently, they have a duty to act in the best financial interest of the beneficiaries, and they are very often nervous about holding wasting or volatile or exotic assets, you know, like Picasso paintings or expensive yacht. I once had a client who wanted to buy a helicopter into a trust, and trustees get very nervous about holding such assets. You don't have this problem of foundation because it's a legal entity. It can hold these assets directly, and counsel are not personally liable, right? So as I said here, liability of counsel is less onerous. And therefore, I would have no problem being a council member of a foundation that owns exotic assets. Corporate personality of a foundation means that sham issues are less likely to occur unless the veil is lifted. Now, for those of you who know, who are versed in company law, for example, you know that it's very difficult to lift the veil in the context of a company. And the same principles, I think, would apply to foundations if the veil was to be lifted. So it's not as easy as holding a trust to be a sham. In foundations, it's easier to allow the client to have control and influence over the foundation's assets than it is for trust. For example, it would be less risky for a founder to have a reserve power to direct investments in the case of a foundation than a trust, because in a trust, there is an overriding duty to monitor the performance of investment, which a trustee is subject to. A council is not subject to that type of duty. But most importantly, and my experience of dealing with Asian clients, you know, Indian clients and African clients is that, and I also talk for me, right? It's very difficult to actually give away control over your assets to a third party. You know, it's not in our culture, right, to just give away control over your hard-earned assets to a third-party trustee. You know, culturally, it's very difficult for us to accept that. And therefore, for such clients, and including myself, I'd rather have a foundation than have a trust. In fact, I have a foundation and not a trust, simply because I want to continue to have influence and to exercise certain powers in respect of my assets, which would be very hard to achieve with a trust. And finally, they can also be used as orphan SPVs in structured finance transactions. Nothing to do with estate planning. I just took that off the hat. But foundations can also be used as corporate structures and even as an alternative to classic corporate structures. There's no one size fits all. Obviously, the foundation would not be appealing to all clients. But I think if you want to have control and influence, if you want to have your assets held in an entity and not by, a trustee, if you want to have exotic assets into the structure, I think a foundation is more appropriate for you than a trust. Okay. Obviously, for some clients, the trust will still remain the preferred vehicle. But more and more, I see that clients are moving towards the foundation.